James Garner, is James Garner here?
I'm here.
Buckle up, guys. Today we're stepping into a courtroom where confidence, ego, and misunderstanding of the law collide head-on. From the very start, this case tells you exactly where it's headed. A defendant fully convinced the rules don't apply to him, a judge known for zero tolerance, and a guaranteed outcome waiting at the end. The irony is thick, the warning signs are obvious, and the ending is already written. The only question is how fast it all unravels.
Good morning to you, sir.
Good morning.
What is your middle name? Can you remove your hat, please? And your scarf. What is your middle name, Mr. Garner?
Errol.
Earl?
No.
He's on the 1:30 docket, Your Honor, I believe.
James Garner. Earl Garner. James Errol Garner, right?
Yes.
You are on the 1:30 docket.
All right, guys, notice how tension forms immediately. Something as simple as courtroom decorum becomes a power struggle. The hat, the name, the tone, none of it is accidental. This is the first moment where authority is tested, and instead of de-escalating, the defendant quietly signals resistance. In court, first impressions matter, and right here, the court learns it's dealing with someone who won't play along.
You want me to come down? Okay, I'm on my way down.
Mr. Garner, do you want to offer on these or do you want to go to trial?
I would like to know what the charges are.
All right, guys, this is where reality crashes in. One charge turns into many, and suddenly the weight of the situation becomes undeniable. As the list grows longer, the court lays out the consequences in plain language. Jail time, fines, warrants, it's all on the table. What's striking is how calm the delivery is compared to how severe the exposure actually is. This is the moment most defendants wake up. He doesn't.
City of Detroit versus James Earl Garner, case number SP 11000435, counts 1, 2, and 3. SP 11695. Those are driving license expired, misdemeanor, no insurance misdemeanor. Thank you. And an improper plate misdemeanor, all of them punishable by maximum possible penalty of 93 days in jail and or $500 in fines. SP 1169507, counts 1 and counts 2, expired license and no insurance misdemeanor, both punishable by 93 days in jail and or $500 in fines. SP 1169521, same improper plates, same punishment, $500 in 93 days in jail and or $500 in fines, maximum possible penalty. SP 1223079, driver one license suspended. SP 1273761, SP 1927512. 3 of those tickets are all punishable by 93 days in jail and or $500 in fines. SP 1547006, counts 1, counts 2, and counts 3. Those are civil infractions. SP 1547407, counts 1 and counts 2. Count 1 being a driver while license suspended repeat offender. This one is in warrant status, probably an old case that he didn't pay. SP 800104, counts 1 and counts 2. 1 being an unregistered untitled, he owes $1,194 on that. And SP and count 2 of that is a drug while license improper. It looks like he has a $114 fine on that. State of Michigan versus James Earl Garner, case number SX 36268561. That is a drug law license expired. And that will be $500 maximum possible penalty, 93 days in jail and.
All right, guys, this is the turning point. The decision to represent himself isn't confidence, it's a gamble. The public defender steps aside, and with that, the safety net disappears. The courtroom shifts energy instantly because now the defendant is solely responsible for every word spoken. Judges hear this all the time, and it rarely ends well. From this moment forward, every mistake is his alone.
Sherika Harris on behalf of Mr. Garner. Mr. Garner, please state your name for the record.
First off, I do have a couple.
You got to
of
state your
questions.
name first. You got to state your name first.
No,
Let's start there.
wait a minute, Ms. Harris. Wait a minute, Ms. Harris. I think Mr. Garner is going to represent himself. Am I correct, Mr. Garner?
I'm representing myself in what? I mean,
All right, guys, here comes the script the court has heard 100 times. No victim, no crime. Jurisdiction challenges. Common law arguments. On paper, it sounds intellectual. In reality, it's disconnected from how courts actually work. The judge listens, responds, and moves on, because these arguments don't stop cases, they speed them toward consequences. This is where the defendant believes he's winning, but is already losing.
I'm confused about what's actually going on. First off, who's alleging these charges? That's what I'm curious about.
State of Michigan, City of Detroit.
Okay, well, if that's the case, there's a common law principle which states that for there to be a crime, there must be a victim. Corpus delicti. The state cannot be the injured party. And in the absence of a victim, there can be no crime.
We want to do it.
Withdrawing my name from the record on that one. Thank you.
I know. How do you want to proceed, Mr. Garner? You set the matter. I'll enter a not guilty plea on his behalf. Give him a $0 bond. Either set the matter for trial, or I'll wait for the city to give you an offer. What do you want to do?
Well, the court hasn't even established jurisdiction. I mean, in order for jurisdiction, the jurisdiction has to be established first, and there's no jurisdiction established. And once jurisdiction is challenged, that must be settled before charges can.
All right, guys, this is the final warning, and it's crystal clear. The judge draws a line and explains the rules in the simplest possible terms. Answer the question or face contempt. No debates. No speeches. No theories. This is the moment that separates outcomes. Many defendants correct course right here. He doesn't. And once that warning is issued on the record, the ending becomes inevitable.
Do you want to put that in a motion, sir?
As far as I'm concerned, any and all charges must be dismissed because there is no complaining witness. And the state cannot be.
Well, I'm not gonna listen. If that's your motion, I'm gonna deny the motion. Okay, so all we're gonna do now, we're not gonna keep going back and forth. Either you take an offer or you set the matter for trial. Which one do you want?
Respectfully, in order for this to continue, there must be a complaining witness, and the state cannot be a complaining witness. Now, if I'm entitled to a fair trial, the law states there must be a victim. I'm just requesting, who is the victim? Who did I injure?
The citizens of the city of Detroit and the state of Michigan are the victims.
The state cannot be a victim. And if that's the case,
I said the citizens of the city of Detroit and the state of Michigan are the victims.
if that's the case,
Mr. Garner, can we just go into a breakout room and then maybe I can give you a little bit of advice to assist you with moving forward? Would you be agreeable to that?
Sure.
Okay, awesome.
All right, guys, this is the collapse. The courtroom authority asserts itself, and the consequences arrive instantly. 30 days. No early release. No debate. What's important here is that this sentence isn't about the original charges, it's about behavior in court. The irony is brutal. The attempt to defend freedom results in immediate loss of it, all because instructions were ignored.
Back on the record with Garner. What do you want to do, Mr. Garner? Do you want a trial date or you want an offer? Those are really your only two options.
Okay, since we are on the record, all I'm asking for is the
Okay, one last time. Now listen, here's how it's gonna go from this point on. If you don't answer the question that I asked specifically, then I'm gonna hold you in contempt of court, and we're gonna move from that point on, right?
telling me
Mr. Garner, we're
so
not
you're
gonna
telling
have
me
a
that the court is just gonna
we're not gonna
violate
have
the
a
Constitution and the
conversation.
law.
Stop, sir. Stop, sir. Now, that's the last time I'm gonna ask you to.
On the law. Is that what I'm hearing?
All right.
I'm asking.
I'm gonna hold Mr. Garner in contempt of court. He is directly violating the court's order. I've asked him repeatedly to not interfere or add any extra commentary to this case. I've given him ample time to answer the court's question, and he continues to refuse to do so. So now I'm gonna hold you in contempt, and I'm gonna sentence you to 30 days Wayne County Jail, no early release.
So that means that the court is just gonna violate my rights because I'm defending myself? Is that what I'm hearing?
30 days, Wayne County Jail, no early release. That'll give you some chance and some time to read up on your rights, okay? Fill out the contempt papers, Madam. So I'm gonna order you to turn yourself in today, Mr. Garner, to start that jail time, okay?
So I have a question.
I'm not answering any more of your questions. Turn yourself in to the Wayne County Jail today.
So the court is gonna be in direct violation of my rights in the law. Is that where we're standing?
If that's how you feel. Have a good day, sir.
All right, guys, this ending ties everything together. We're reminded that this isn't an isolated incident, it's a pattern. Contempt cases don't pause life, they interrupt it completely. Jobs, families, freedom, all put on hold over courtroom conduct. The lesson is simple and repeatable. Courts don't argue philosophy, they enforce procedure. If you enjoyed this breakdown, like the video, subscribe to the channel, and we'll see you in the next video.